My lord. That's it, I'll have to bring it on record, my lord. We have filed an initial affidavit. God bless you. All for. No, call for a affidavit filed for item 8. You give the yes memo. Yes, madam.
Yes. I did mention item number 16, my lord. We have taken concern from other side, my lord.
16?
16, 16. We have some development.
You are for
Petitioner, my lord.
Mr. Dr. B.
AK Azad.
Mr. A.K. Ajad, learned counsel for the petitioner, with consent from the other side, seeks 2 weeks accommodation in the petition. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry.
There is an interim order that may.
Interim, if any, shall continue till the next date of listing.
May it please your lordship. May it please your lordship. Lordship, I beg to mention item number 18.
Item number
18, lordship. Lordship may kindly adjourn the matter for today.
you are for
The petitioner, lordship, on behalf of Mr. J. Chutia.
it's a 420. We'll see. What is the problem?
Lordship, my senior has some personal difficulties today. My senior has some personal difficulties.
You
today.
try. Item 18. Have you informed the other side?
No, lordship.
No. Then you wait. Yes.
They're here, lordship. Lordship, I'm going to respond in.
Any objection?
No, lordship.
MS,
Please show here, lordship.
please give your name. MS so-and-so, learned counsel for the petitioner seeks 2 weeks, 1 week adjournment in the petition on the ground that the conducting counsel has some personal difficulty. Prayer is not opposed by MS.
A. Pine.
A. Payang, learned counsel appearing for the respondent. Relist after 1 week on a date to be fixed by the registry.
Much obliged, lordship.
May I please, Lordship? Lordship, I beg to mention item number 14 of daily list on behalf of Mr. P. Talukdar. He is unable to come to the court as he is suffering from back pain, Lordship.
Back pain.
Yes, Lordship. Matter may be adjourned for a week, Lordship.
Item 14.
14, yes, Lordship.
As prayed for by
A dash, Lordship.
MSA Das, learned counsel for the petitioner, on the ground that Mr. P. Talukdar, learned counsel for the petitioner who is conducting the case is due to medical ground is unable to come to the court today, relist after 1 week. 1 week or 2 weeks?
1 week, Lordship.
1 week on a date to be fixed by the registry.
Obvious, Lordship.
May I please the lordship? With the consent from the other side, lordship, I beg to mention item number 4, lordship. This matter has come up today after 7 years of period, lordship. So it was last listed on 2018. So lordship, we need to obtain some instruction from the petitioner.
What
Lord-
instruction you want? Wait, let us see. We'll see what is this matter. If needed, we'll admit it. We'll see what it is.
Like-
Lordship, in this matter, I am appearing for respondent number 2. Yeah, in this matter.
Wait for some time.
Much obliged.
It will be called.
May it please your lordship. Lordship, I beg to mention item number 17, your lordship. On behalf of J. Rabha, your lordship, he is not well. Matter may be adjourned for the
MS?
day. J. Rabha, your lordship.
MS,
A dash, your lordship.
MSA Das, Learned Counsel seeks accommodation in the petition on the ground that the conducting counsel, Mr. J. Rabha, is indisposed. Prayer is allowed, relist on such and such date. You are there in this matter, Mr. Roy?
No, madam.
Relist after relist that are date.
On 9 different.
Obliged.
Yes, Mr. Roy?
Item number 12, my lord. It's old matter, my lord, but I need 1 day inspection, my lord, so that I can get the proper
Your name, you are appearing for
the accused, my lord,
for the petitioner.
petitioner. 1 day time, my lord, only.
Item 12.
12.
Mr. J. Royal and a senior counsel assisted by Mr. R. Chaudhary.
You choose.
U. Chaudhary, sorry. Mr. U. Chaudhary, learned counsel for the petitioner, seeks 1 week, six accommodation for the day in
Day.
order to get in touch with the client as the matter pertains to 2012. Stop prayer is allowed, relist after 1 week. You want any specific date?
Lordship, on first, my lord?
1st of April?
Yes, my lord.
All right, relist on 1/4/2025.
But item number 11, my lord.
11,
11.
sorry, not 12, huh? 11.
Oblige, my lord.
For ambition, item number 1.
Yes, Mr. Chaudhary, what is this petition you are
Well, it's
seeking
the
quashing
complaint-
of?
Complaint case, my lord, quashing, my lord. Complainant, my lord, as per the, my lord, the order passed,
1 second.
my lord.
Yes, Mr. Chaudhary.
My lord, say complaint was lodged by the, my lord, the present petitioner. My lord, that he has been defamed, my lord.
He has?
He has been defamed. So under section 499 IPC, my lord, that complaint was lodged, my lord. But that complaint cognizance was not taken. And my lord, he preferred a revision that also dismissed, my lord.
You are for the,
I am for the, my lord, the complainant petitioner.
which is the order against which you have come?
First, lordship, there are two orders, my lord. One is passed by the magistrate, my lord, and subsequently, my lord, session judge.
Additional district session judge.
Yes,
That is the order against which you have come.
yes, my lord.
Because an FIR was filed against you.
Yes, my lord. I was a government servant, my lord. So against me, an
Defamatory, because an FIR was filed.
FIR was filed, my lord. And in the FIR, my lord, I had to approach the, my lord, session court for, my lord, anticipatory bail. Bail was granted. They are also reflected.
What happened to that FIR?
FIR, that case is against, my lord, my wife and some other accused were also there. Against me, my lord, no search sheet was submitted.
So then, why if cognizance has to be taken in such situation, people will be scared of filing FIR.
That is the-
Everyone will say that it is defaming their, because they are a government servant or for the post they are holding. If the FIR, if there is no charge sheet, you have been already given a clean sheet.
only thing, my lord, without any material, my lord, this FIR was lost,
For that, you may have some other remedies,
my lord.
but are you following what I am saying?
Yes, yes.
Everyone,
Only thing, my lord, whether the complaint filed by me, my lord, whether a prima facie case of, my lord, 499 IPC has been made out against the, my lord, the opposite party respondent number 2, my lord.
IPC. 490,
429 IPC,
490.
9, my lord. That is defamation, man. Our complaint, we have annexed it, my lord, annexer, my lord, 6. Page
One
number
second,
38.
let me just see the section first. Whoever by words either spoken or intended to be read, or by signs or by visible representations, makes or publishes any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is said, except in the cases hereinafter expected, to defame that person. It may amount to defamation to impute anything to a deceased person. It may amount to
is a-
defamation to make an imputation concerning a company. An imputation in the form of an alternative. Here nothing is published. It is an FIR.
My lord.
Second exception, it is not defamation to express in good faith any opinion. That is different. Third exception, it is not defamation to express in good faith any opinion, whatever, respecting the conduct of any person touching any public question. Mr. Chaudhary, I am of the opinion that prima facie it is not defamation just because an FIR has been lodged.
my lord.
In fact, since there was no materials, charge sheet is not filed against you.
Cognizance was not taken.
Correct.
Cognizance.
It was not taken in that FIR. Nothing is wrong.
FIR was, my lord, one a separate one, my lord. First, my lord, FIR was lodged against me, my lord.
That's right. But in that FIR, cognizance was not taken.
No.
And you have filed this case, this complaint, seeking,
FIR, my lord,
alleging that because of that FIR, your image has been defamed.
my lord.
And therefore you wanted that cognizance be taken under section 499.
Yeah,
Correct?
yeah.
But according to me, rightly, both the courts have not taken, have not taken cognizance in your FIR. Because there is no materials of 499. He has not published it. It is not in a, I could have understood if he had said something about you in a Facebook, in a social platform,
Those were not there.
then
Only that FIR was lost and FIR becomes. a-
lodging of an FIR cannot be so many times, so many FIRs are there. It's not necessary every allegation in the FIR is going to be correct. It is for the police. There is a mechanism. Police are not accepted to accept the FIR and register mechanically. The process is there. Investigation is carried out. If nothing is there, charge sheet will not be issued against you. Even if charge sheet is issued, magistrate has the power not to frame the charge.
My lord.
You have the right for seeking discharge. There are so many safeguards.
Those were there, my
Then
lord.
where is the question of defamation here? I'm
Oh.
sorry.
My lord.
Yes, who is appearing in the other side?
Other side, my lord, there is a order is passed, my lord, that in spite of receipt of.
Okay,
notice-
service is deemed completed. Yes,
Yes, just formal party, madam, in this.
yes, but you are an APP.
Yes.
You are an officer of the
Lord,
court.
Lord.
You have a duty to assist.
Yes,
Yes.
madam.
What do you think?
Record is also.
No, on the issue.
Lost.
Forget the facts. It's a very simple issue. Can a section 499 be registered or framed against the accused on merely on the basis that he had lodged an FIR
Also.
against the against the complainant? That is the issue.
Yes, yes,
That cannot be, my lord.
All right,
But
let
the-
me see your
because-
complaint now.
my lord.
That is the issue, my lord.
That is the issue.
Then everybody will, my lord, file.
Exactly. That is what I am saying.
Yes.
It is going to open, Mr. Chaudhary. You will have a difficulty. I'm telling you.
Yes.
You are you are dealing. You are one of the leading criminal lawyers of the state.
Complaint I have filed at page 38, my lord. Annex 6.
And it appears that both the courts have passed detailed orders.
Yes, my lord. Elaborately
This is
discussed.
revision. This is revision jurisdiction you are seeking. No, criminal.
No,
petition.
my lord.
Petition I have filed.
Criminal
Yes,
petition.
complaint is at page.
38, my lord.
Yes. You are Sirajul Islam.
I am Sirajul Islam, my lord, complainant. Accused is my lord Firoz Ahmed. I am a my lord government servant working in as a LD assistant, my
Okay.
lord. Para
Yes.
1,
Yes, read.
page 39, lordship.
Yes, yes.
That a complainant is an LD assistant in the office of Juria Development Block. Further, he belongs to a respectable family. His residence is at so and so place. He daily goes to the said office of so and so by his own vehicle from his own residence, discharges his duty and returns in the evening to his own house. The distance of the office of Juria Development Board from the house of the complainant is about 20 kilometers. On 21/6/14, the complainant in a usual time attended office and completion of his duty returned back to his house in the evening. The accused person residing at Madhupur so-and-so from Nagaon works as an advocate's clerk in the Advocates Clerks Association at Nagaon. The distance between Madhupur and Pup Salmara is not less than 20 to 22 kilometers. The wife of the complainant so-and-so lodged an Azahar against the maternal aunt of the accused so-and-so in respect of an incident that took place on so-and-so, which has been registered as Rupohi at PS case number so-and-so, and investigation was going on. Out of grass of the same, the accused person in retaliation with Milai and with an intention to criminally defame, to deceive him before the public, affecting his good reputation, lodged an FIR to the Rupohi police station in his own writing, making false, baseless, and malafide accusation, knowing that the same was not correct. The accused person also stated that accused number so-and-so with an intention to kill my maternal aunt, sove her in the water of pond, catching hold of her neck. Further, in the beginning of the said Azahar, he wrote that Sirazul Islam, along with other accused persons, armed with deadly weapon, caused injury to the maternal aunt of the accused so-and-so by assaulting her out of previous grass, knowing
How
fully
can
that
you say that the said Ijazah written by the accused himself was published on so-and-so at Rupahihat PS?
it was given to the my lord police
Correct,
station.
but that is not publication.
But that becomes the my lord once it is registered.
How can it be publication, Mr. Chaudhary? An FIR is, if an FIR is lodged, it is not publication. It is not made available to the public. In fact, there is a procedure, I believe, it cannot, if merely someone asks, he will not be given a copy of the FIR, correct?
My lord.
Where is that mechanism? How the FIR copy is made available to the accused, or if some,
The informant certified copy is to be applied, my lord, only then you will get it, my lord.
where, how can the word published? It's a misnomer. Sorry, Mr. Chaudhary, I read it.
I leave it to your lordship, my
I
lord.
read it.
I didn't have the contact with the my lord, my client also. Today I rang up, he didn't pick up.
All
Whether
right.
it-
That is all right. There is nothing. Heard Mr. B.M. Chaudhary, learned counsel appearing for the petitioner. Stop. Also heard Mr. M.P. Goswami, learned APP for the state respondent. None appears for the respondent number
Two, my lord.
2 on call, pertinent that by order dated 13/2/2019, this court deemed service to be completed against the respondent number 2. However, there has been no representation on behalf of respondent number 2, despite of receipt of notice till date. Stop. Anything, Mr. Chaudhary?
No question.
Anything?
No.
He's found some case law.
One Supreme Court, my lord, the Supreme Court has recognized that filing a false first information report can constitute defamation, allowing the falsely implicated individual to pursue a defamation case against the FIR who filed a false FIR. False allegation in FIR in a case so and so. We
I
are
think
filing.
It could be in the context of that case.
That will be, my lord, because it is also there, mere filing of a false FIR
Hmm.
does not automatically constitute.
That is what
defamation.
is my view. And you see, both the courts have, and specifically in this case, cognizance was not taken in your FIR. Nothing has, therefore, there is no question of any defamation to you. And it was not published anywhere. It cannot be said it is published in the you see, in a given fact, suppose a lot of things have been published about that person in the newspapers, then perhaps his image before the public could have been tarnished because of a wrong FIR. So it would depend on facts, just
Yeah.
mere filing, because and nothing of that sort has been brought to the notice of the court. There is nothing on record. You have not said that these has been done, that he has also given press release against you. These are not there.
It is not there. my lord.
So in a given fact, in a given situation, yes,
That
you're
may
right.
be.
It could be, but not
My lord.
mere filing. Better print it a little bit. This is control.
Case number 2, Rajendra Kumar.
This petition is filed under section 482 CRPC, seeking quashing of the order dated
30/12/15.
30/12/2015, passed by the learned Additional Session Judge FTC Nagaon, hereinafter referred to as the Appellate Court. Appellate Court.
Revisional court.
Revi-
Revision was signed.
That was also a revision.
Yes.
Revisional Court in CM number 13N of 2015, dismissing the criminal revision filed a petition, whereby the criminal revision filed under section 397, 399 of CRPC against the order dated 4/2/2015, passed by the learned SDJM Sadar Nagaon, within bracket hereinafter referred to as the Magistrate Court,
Yes, my lord.
in CR case number 1052 of 2014, whereby the Magistrate Court was pleased to decline issue process against the accused person for the offense punishable under section 500 of IPC, comma, a full stop. The facts of the case is that the petitioner, who is a government servant working as LD assistant in the office of Juria Development Block and Anchalik Panchayat, situated at Nagaon in the district of Nagaon, Assam, filed complaint or FIR.
We have lost complaint. Our case is complaint, my lord. The original was FIR.
So
Against me.
complaint is, no, your complaint is in which page?
At page 38, my lord. CR case number 1052 of 2014.
Filed a complaint
Against respondent number 2, my lord.
being CR number 1052/14 on date is available
My lord, on 14/10/2014.
on 14/10/2014
2014. Yes.
before the
CGM.
jurisdictional magistrate court against the respondent number 2,
Yes.
alleging inter alia that since the wife of the petitioner lodged an ejahar against the maternal aunt of the accused, which was registered as Rupahi Hut PS case number 286/2014 under section 447-323-294 of IPC, comma, out of grudge, comma, the accused number 2 with malified intention and criminal and intention, with the intention to criminally defame and deceive the image of the petitioner before the public, lodged an izahar, lodged an FIR being Rupahi Hut PS case number 287 of 2014 under section 147, 148, 325, 307 IPC against the petitioner. Accordingly, where is the magistrate's order?
Accordingly, my lord, investigation was carried out. my lord,
Accordingly, investigation was carried out,
And finding no material, my lord.
and upon finding no sufficient material against the petitioner, against the respondent number 2, comma, no,
Against the, my lord, petitioner, my lord.
against the
petitioner.
petitioner, against the petitioner,
My lord, no charge sheet has been submitted against him.
no charge sheet was submitted against the petitioner. Stop. The petitioner, where is that first petition, the first judgment of the magistrate court?
My lord, being agreed, my lord, that.
412. 412.
Then, my lord, subsequently he filed a complaint, my lord, before the magistrate that he has been defamed because of the lodging of the FIR, my lord.
No. I am talking about, Mr. Chaudhary, in that complaint that you had filed,
My lord.
after filing, what happened?
Filing of the complaint, my lord, magistrate did not take any complaint.
Where is that order?
My lord,
OP,
yes.
please delete that part.
That lordship will find as,
last
my lord,
two
page
sentences
50,
which I said,
59, my lord.
after investigation, finding no materials, no charges, that is not required to be said there. No, I was actually referring to your complaint.
My lord.
I am just saying the facts.
My lord.
I will come back to all that when I am dealing with
My
it.
lord.
In
Then, my
your
lord,
complaint,
white order dated at page, my lord, 59, lordship will find. White order dated 4, 04.
215. 4-15.
Yes.
Thereafter, the
4 to 15, my lord.
jurisdictional magistrate court, upon perusing the complaint petition and the statements of the complaint
And his witnesses, my lord.
and the witnesses,
Court has come to a finding that, my lord, failure on the part of the complainant to make out a prima facie case to attract the ingredients of the alleged offence, the instant case is dismissed. That is, lordship.
was of the opinion that no
Prima facie
case, no criminal case is made out against the respondent number 2,
Two.
and accordingly, by order,
That
by judgment and order dated 4/2/2015,
complaint was dismissed, my lord.
the complaint
Was
filed by
dis-
the petitioner was dismissed. Stop. I think one connection has stopped. So that complaint. Nothing. Next para. Being aggrieved by the aforesaid order of the magistrate, dismissing the complaint filed by the petitioner filed a revision petition under section 397, 399, 401 CRPC before the revision court, wherein the revision court, after an elaborate consideration of the materials available on record and the submissions made by the learned counsels appearing for the contending parties, was pleased to hold by order dated 30/12/2015 that there is no irregularity or illegality committed by the magistrate court in dismissing the complaint, and accordingly dismiss the revision petition. Stop. Against the said dismissal of the revision petition by the revisional court, the instant
Criminal petition has been
criminal petition has been filed seeking quashing of the said order of the revisional court. Stop. Mr. Chaudhary, learned counsel for the petitioner submits that since because of filing of an submits that the FIR in the FIR filed by the
respondent number 2.
respondent number 2 against the petitioner, the police authorities, upon finding no materials against the petitioner, submitted no
Fine.
charge sheet against the
Final
petitioner.
report, madam.
Submitted final closure report against the petitioner. Hence, it is apparent that the allegations are false and merely set out against the petitioner in order to tarnish his image. Accordingly, he submits that a clear case of criminal defamation is made out on the body of the averment set out in the complaint. And hence, the order of the revisional court in dismissing the order of the magistrate court in dismissing the complaint is totally perverse and bad in law and warrants interference from this court while exercising quashing jurisdiction. Stop. Just full stop. Per contra, Mr. Goswami, learned EPP for the state respondent submits that
Sorry, bro. Bye.
mere filing of an FIR automatically cannot constitute a criminal defamation against the informant. He further submits that there is no whisper as regards the petitioner, as regards the respondent number 2 having published anything in the social platform or in the newspaper, etc., which would constitute defamation, which if published would have tarnished the image of the petitioner before the public. Stop. He accordingly submits that the order of the revision court dismissing upholding the order of the magistrate court dismissing the said complaint warrants no interference from this court. Stop. Heard, perused. It appears that The respondent number 2 had lodged an ijahar on 21/6/2014 before the jurisdictional police station, alleging that the petitioner, along with the other co-accused, assaulted his maternal aunt on 21/6/2014, causing grievous injuries to her person by using deadly weapons. It appears that upon receipt of the said FIR, a case was registered being Rupahihat PS case number 287 of 2014 under section 147, 148, 325, 307 IPC against the petitioner along with others. It appears that in the bail application filed by, in the anticipatory bail application filed by the wife of the petitioner, no.
By the petitioner.
In the anticipatory bail application filed by the petitioner, the learned additional session judge Nagaon, by order dated 10/7/2015, was pleased to grant bail, pre-arrest bail to the petitioner, correct?
Hello.
Stop. It further appears that upon completion of the investigation, the police, the investigation, the jurisdictional investigation officer, though filed charge sheet against the other co-accused named in the FIR, but sought closure against the petitioner on the ground that there was no evidence of his involvement in the said case. So is there an order of the magistrate accepting the FIR or?
That has not reflected here, my lord.
Stop. It appears that the petitioner thereafter lodged filed the instant complaint alleging inter alia that the respondent number 2, with the intention to tarnish the image of his before his colleagues and public, has falsely robed him in the said FIR. Stop. Apt to refer the complaint dated 14. What was the date?
Lodging of complaint, my lord.
The complaint
14/10/2014.
the complaint dated 14
10/2014.
2014 is reads as hereunder. A to A, page 38. Huh? Apparent reading of the aforesaid complaint that because that the same has been filed against the petitioner only on the ground that he had made allegation against the petitioner in the FIR in question, along with the other co-accused. It appears that the accordingly, it is stated in the complaint that the FIR, which was written by the respondent number 2 himself, was published on 21/6/2014 at the police station. And on 22/6/2014 in the Court of Honorable Chief Judicial Magistrate, and on 10/7/2014 in the Court of Session Judge. Stop. It is beyond the understanding of this court as how an lodging of an FIR in a jurisdictional police station be said to have been published in the police station. An FIR is not even put in the notice board of the jurisdictional police station. Mere filing of an FIR automatically cannot constitute an offense of criminal defamation. So, if today this court holds the same, it would lead to a dangerous position where a person would be scared to file an FIR on the ground that in the event the police submits FIR rightly or wrongly against the petitioner, against the accused, he may be not he, a criminal defamation case may be lodged against him. It further appears that in the in the FIR filed by the respondent number 2 against the petitioner, though charge sheet was submitted against the other co-accused, however, upon being satisfied that there was no materials against the petitioner, closure report against the petitioner was submitted. It is apparent that no harm has been caused to the petitioner since he has already been, since his name has already been struck off from the, since he was not proceeded criminally in the said FIR. It appears that the magistrate court has how did you start? No, apt to refer to the relevant paragraphs of the order dated 4/2/2015 passed by the Magistrate Court. Quote unquote, page 61, huh? A to A. Okay. Page 61 and 62. It appears that the magistrate court has taken the correct position, has taken into account the ingredients of section 500, ingredients of section 499 IPC, and after perusing the complaint and the materials available, was pleased to observe that the same on the face of it does not indicate that any loss or harm was caused to the complainant's, to the petitioner's reputation, even assuming that bus full stop, huh? It appears that the magistrate court has also taken into account that the said FIR filed against the petitioner had resulted in a charge sheet against the co-accused, though the case was not sent up against him. And the said case is still pending for trial. Stop. It appears that the appellate court apt also to refer to the relevant paragraphs of the judgment dated 30/12/2015 of the revisional court,
Revision.
which reads as hereunder. Paragraph 8, page 68, 9, 10, 11, 12. Quote unquote. Perusal of the judgment of the appellate of the revisional court, it appears that the revision that it appears that there is no illegality or irregularity committed. You simply say there is no legal infirmities committed by the revisional court. That being so, the criminal petition fails. Accordingly, the criminal petition stands dismissed. No cause.
I'm obliged, Worship.
Item number 2,
Judgment to listen.
May I please your lordship? Lordship, the matter become infructuous because the petitioner already expired, lordship.
MS,
MS R. Kakoti.
MS,
R. Kakoti.
R. Kakoti, learned counsel for the petitioner, submits that on top you say heard MS Kakoti for petitioner. Yes, Mr.
B. Hussain,
V. Hussain. Learned
Or private
counsel appearing
respondent number
for the
4.
respondent number
Hussain.
2,
4, my lord.
Huh?
Respondent number 4, Nivedita Mahanto.
respondent number
I am
4,
the informant of this case.
and Mr. MP Goswami, learned EPP for the state respondent. Then you say Miss So-and-so, learned counsel for the petitioner, submits that during the pendency of the criminal petition, the petitioner has expired, and in support of the aforesaid submissions, she places the death certificate dated 19/7/2022, which indicates that the petitioner had expired on
18/4/2021.
18/4/2021, my lord.
18/4/2021. Stop. A copy of the said that certificate is kept on record and marked as X. Itu mark করে দিব দেই। In view of the aforesaid endorsement and the certificate placed before this court, nothing survives for adjudication in this criminal petition. Accordingly, criminal petition stands dismissed.
On submission, my
Has
lord,
become infractious.
there was last order matter 22/1/22 or 21. I said some time for settlement of the amicable settlement between the parties. The amicable settlement was also done, husband and wife.
Mr. So-and-so, who's Mr. B. Hussain, learned, Mr. MDB Hussain, learned counsel for the respondent also submits that before the death,
Date, my lord.
that before the death of the petitioner, the matter has been already amicably settled between them,
Husband and wife.
between them, between the petitioner and the respondent number
Yes, four.
four. Stop. In
There was
view of the
another.
above, nothing survives for adjudication as the matter has become infractious. Matter stands closed.
Mas-
Item number 3.
Please, I am on behalf of AM Khan Lordship. I am on behalf of AM Khan Lordship.
Yes.
Lordship, matter may be taken at two Lordship. LCR is liquor Lordship. LCR was not called for Lordship.
2016.
As prayed for, list this matter on Tuesday, Wednesday, Thursday,
Tuesday, Lordship.
Tuesday.
Item number 4.
2 minutes. May I please, your lordship? If this is a case for quashment of an FIR, and here the facts are very interesting, lordship. Probably we will have to call for the status report of that case, lordship, because what has happened, this matter was last listed in 2018, lordship. After 2018, it has been listed now. Lordship may kindly see what has happened in Vashishta PS. One FIR was lost. Petitioner number 1 and 2 are the police officers. Petitioner number 1, Hemanta Kumar Das, lordship. At that relevant point of time, he was DCP East. So his responsibility is to supervise. Petitioner number 2 was the OC of the Vashishta PS. So in Vashishta PS, one FIR is lost. I have annexed that FIR here. I will show you, lordship. There is annexion number 1, page number 19, lordship. Your lordship has kindly got the FIR, lordship. Page number 17, your lordship can have a look, lordship. Vashishta PS, lordship. An FIR has been lodged, lordship, by one Dulal Boda. Now, in this FIR, there are certain allegations against the respondent number 2 of this present petition, lordship. Respondent number 2, at that relevant point of time, happens to be SP Kachar. Now, what he did, lordship will kindly see. The impugned
You
FIR.
want status of what?
I will say, lordship. I will satisfy your lordship. What status of
No,
what I
but
want.
what status report you want?
Yes, I will come. Lordship may kindly come to page 56 now. Page 56. Lordship has kindly find it, lordship, page 56. Lordship, kindly see, place of occurrence is 360 kilometers from north. Can that be, lordship? I am a police officer. My duty is, if a cognizable offense is placed before me, I have to register an FIR. I am DCP East. My duty it is to supervise the investigation. Only because I have supervised the investigation and I have registered an FIR, against me another FIR is registered. And this FIR is registered in 2016. Today we are in 2025. We don't know the status of investigation, lordship.
Status of investigation in respect of which FIR?
This FIR, lordship, the impugned FIR.
That is FIR number 2562,
Lordship.
dated 29/9/16.
Lordship.
You have it.
Report, status report also.
It is submitted at the bar that before proceeding further in the matter, the status report in connection to FI, in connection to PS Silchar,
Silchar PS case number
case number
2562.
FIR number 2562 dated 29/9/16 be called, would be essential to be called for.
Call for.
Accordingly, let Mr. So-and-so Locker, learned APP for the state, place the status report of the said FIR on the next date of listing. Released on
After vacation, Lordship, any date? Diploma.
On orders, item number 5.
why is this for orders? Yes, where is Mr. Alamgir? He was allowed to take fresh steps. What happened? Office note indicates no AD card, nothing. None appears for the petitioner on call. It appears that by order dated 10/2/2020, the learned counsel appearing for the petitioner was allowed to take fresh steps for service of notice on respondent number 2 by registered post with AD as well as by usual process. However, the office note dated 19/3/2025 indicates that neither AD card nor unserved notice nor any service report in respect of the respondent number 2 has been received back by the section till date. Relist next week at the date deduct in the order column with remark for dismissal.
Item number 6.
Yes,
Have
Mr.
please, your
Biswas.
lordship. Office note indicate that ID has not come. 19/3/125 kindly produce my lord.
What
Order
has
date.
not come?
Acknowledgement card.
So 2016 matter, you take fresh steps.
So my lord, question is that my lord, it is the case, old case of my lord, 18 my lord.
Yes, but
And,
what is done?
I do not know what is the, yesterday I tried to
You
contact.
check, we'll give you time.
If your lordship direct me, I'll take fresh steps again.
That's what.
Throw, my lord.
It
throw the-
appears that the office note dated 19/3/2025 indicates that neither AD card nor any unserved notice in respect of the respondent number 2 has been received back by the section till date. Mr. S.C. Biswas, learned counsel for the petitioner seeks 6
fresh step by through CGM.
2 weeks time to 6 accommodation in order to take fresh steps on
Through CGM Kajal government.
upon the respondent number 2 through
CGM Kajal government.
through CGM
Kajalgaon.
Kajalgaon. Prayer is allowed, relist after 2 weeks on a date to be fixed by the registrar.
Diploma.
Item number 7.
Yes, Mr. Sharma?
May I plead the lordship? Lordship, I'm sorry I could not appear on the last date. So your lordship was pleased to direct service on the petitioner. So
You are appearing now?
I'm appearing, my lord.
Okay.
So lordship, in this matter, we had filed an affidavit,
Is it, this matter is already admitted, not that
not admitted, my lord.
you are
Lordship,
challenging the complaint?
yes, complaint because, my lord, I had initially preferred an petition before the learned family court on the ground that the respondent married me by concealing her religion.
Posted for him admission.
Admission, but in the meantime, lordship may also record the my affidavit, which was regarding service of notice. which was filed on 25/8/23. Because on the first occasion, my lord, the respondent refused to accept the notice, Lordship directed that I file it through the Honorable Court of the Principal Judge Family Court. Accordingly, my lord, on the Lordship, that was filed through the on 28/7/2023, Lordship has directed petition along with a copy of the petition and the orders passed by this court were submitted before the court of the principal judge, which were received by the counsel for the respondent as she was absent on that day.
You tried through the court. You tried through the court, then a Jari Karak report could be there.
No, Lordship, kindly have a look at the order dated 21/7/23 passed by this honorable court.
21/7.
23, my lord.
Yes, you were directed to take steps. for
Yes,
issuance
justice
of
service
notice.
upon the sole
Correct,
respondent.
but now in your affidavit, you are saying that he did not accept.
No, my lord. Kindly may I read the order?
Yes.
And from the office note dated 19/7/23, it reveals that the petitioner had already filed affidavit in regard to the dusty service upon the sole respondent, and from the affidavit, it reveals that the respondent avoiding the service of the notice on several occasions. The petitioner has approached the respondent to serve the notice. Further, it is submitted by the learned counsel of the
I
petitioner.
read all this from your affidavit.
Yeah.
Yes, what is,
So,
what is?
Lordship, you were directed to serve the notice through the court.
Where is it set through court? The petitioner is directed to take steps for issuance of notice to the respondent number 2. Where is it set
Yes.
through court?
In the same order, my lord, kindly see. Further, it is submitted by the learned counsel for the petitioner that the proceeding under section 125 CRPC is still pending before the learned court
And
below.
hence the notice can also be served before the court
Court
itself.
itself. That
on
was
her
what was done.
appearance before the, so where have you done this?
That was done. I have my affidavit, kindly see, Lordship.
Which affidavit? There are two affidavits.
My affidavit filed on 25/8/23.
20?
25/8/2023.
Yes.
Paragraph 3 of my affidavit, Lordship. That
Where is the acknowledgement and where is the order of the court?
that the learned trial court did not do. Court said you serve the copies, so we have made a
Where is
statement.
the acknowledgement?
No, we filed it before the learned court, my lord.
But before this court, there is nothing, a copy of the.
That is not there. That is not
Then
there.
how will this court know? The court, there is no order, the order of the court is also not there. There is nothing to indicate that before the court you have done it, except your
Because, my lord, when we submitted before.
Mr. Sharma, please understand the difficulty this
Yes,
court
yes,
is having. You
I-
have to
I
give
understand.
something.
I understand.
You have said a copy of acknowledgement of receipt of notice is annexed herewith as annexure 12. Where is this annexure 12? There is no annexure 12 in my,
That should be annexed to the affidavit, lordship.
but where is it? Here annexure 12 is an order of this court.
Yes, on that only the counsel for the respondent. That was done in the court premises itself.
Okay. Heard Mr. A. Sharma, learned counsel appearing for the petitioner, also heard Mr. MP Goswami, learned APP for the state respondent.
We are not.
They're not a party. None appears for the respondent number 2 on call. It appears that pursuant to the order dated 21/7/2023 passed by this court, allowing the petitioner to serve notice upon respondent number 2 before the court where the proceeding under section 125 CRPC is pending, comma, the petitioner accordingly served a copy of the instant criminal petition along with the said order dated 21/7/2023 to the learned counsel appearing for the respondent number 2,
Or sole respondent. Lordship.
appearing for the respondent before the
Principal Judge, Family
before
Court.
the principal judge, family court number 3 at Guwahati.
Lordship.
Stop. In support of the same, the petitioner has filed an affidavit dated 28/8/2023. Paragraph 3, 4 is reproduced hereunder for ready reference. It further appears that it is further apparent from Annexure 12 to the petitioner, to the said affidavit, enclosed to the said affidavit, that one Nipen Chandra Kolita, who is the advocate who is the learned counsel appearing for the respondent before the said court, had received the notice on behalf of the respondent.
My lord.
That being so, service stands complete in respect of respondent.
Lordship.
Stop. Why is it mentioned R2? There is no R2. Sole
No,
respondent.
Lordship. Only sole respondent.
So R2 not respondent. List the matter for admission in the first week of April 2024 on a date to be fixed by the registry.
Lordship, can I only pray that there was an interim order which was not subsequently, because
Nothing. Next.
For hearing, item number 8.
Hello. May I permitted to mention item number 10, my lord. Item number 10 of hearing, my lord. What happened here? I have learned that the appellant has expired.
But 10 is not called, 8 is called.
It is called, but the
Maintenance is over.
should I wait?
Mr. Das.
Should I wait for 10, my lord?
What do you want to, 9 and 10 are connected.
9 and 10 are connected, my lord. They are
9 council is here
9, therefore 9.
and 10,
Lordship, I'm for, on behalf of
Yes,
Mr. M. Holloway, special PPC, he won't be able to
oh,
access the.
Mr.
portal.
Holloway is there.
Yes,
Okay,
CBI.
then he'll not be able to do it.
yes.
In item number 9 and 10, it is an adjournment is sought by MS
T. Begum.
T. Begum, Learned Counsel, on behalf of the on behalf of Mr. M. Holloway,
Special
Standing
PP.
Counsel CBI,
Special
respondent, for the respondent, on the ground that due to the recent engagement of Mr. M. Holloway, Learned Counsel, with the in the Directorate of Prosecution,
Yes.
State of Assam, he shall not be able to continue in the said case as a special prosecutor.
Yes.
Stop. In view of the aforesaid submission, list this matter in May, give a date.
Should I mention about item number 10?
9 and 10 both.
9
Connected.
and 10.
Yes.
10, my lord, as I have said, my lord, I have learned that the appellant has expired.
You have anything?
My lord,
So
that
it
is,
will be abated
it will be a bit, but I will be producing the authentic.
on
report.
that next date.
8 May.
Sure, I think it is okay.
8 May.
For hearing,
8/5.
item number 8.
Obliged.
Lordship has heard this matter earlier, my lord. And Lordship has passed an order, my lord, 26/7/24. Some of the portion of the vernacular version was not legible, my lord, that's right. So we have filed an additional affidavit, my lord, today.
Yes. No, not this court has not heard it earlier.
In the, your coordinate.
Another court, coordinate.
Coordinate.
That's why I was thinking.
No, let's take this one. Yeah, order is 26/7/24.
Yes, I have seen the order.
Yes, yes.
20?
26/7/24, my lord.
Oh, Lordship has appeared one. Oh, yes,
Yes.
on 26/7, but there is an order also, my lord. Last order is of Honorable Justice.
Yes, yes. Okay,
And there is no.
it's ready for hearing now.
Yes, my lord, I have filed an additional affidavit. my
Okay.
lord. So, my lord. My lord, this appeal is against conviction, my lord. Under section 376. Later it was charge sheeted on 370, under section 376, and charge was framed on 376 to F, my lord. So girl was like, my lord, she's 16 years old. Then punishment,
376 to F. Conviction is under 376 to F.
yes, my lord,
Initially, charge sheet was under,
under 376, my lord,
and later on it was converted.
converted, my lord.
Okay. Where is the order of the trial court? You are against the order of the
Eight.
trial court?
Yes, my lord,
Conviction order?
yes, my lord.
Yes.
Page 8, my lord. The judgment, my lord.
Yes.
And there are total 7 number of PW, my lord, prosecution witness and 2 defense witness, my lord.
Yes.
So, my lord, may I go to the prosecution witness, my lord?
Yes. Where do I get them?
Yep, in this new affidavit, my lord. It's clear, my lord.
Total witnesses, you said how many? PW?
7, my lord.
7. And DW?
2, my lord.
2. Yes.
My lord. May I read PW 1, my lord?
Yes, please.
My name is Miss Pinky Boyso. She is the victim, my lord. I know the accused informant Bolendro Boyso is my maternal uncle. It has been 1 year and 7 months since the incident. The incident took place at about 3 p.m. At the time of incident, I was pursuing my study, staying at my maternal uncle's home. On the day, I went to the shop for purchasing sugar and incense sticks. My maternal grandmother sent me to the shop.
Actually, I want to place some judgment, not today, but what happened without entering the merit of the case. My lord, this is your lordship, kindly see this matter was, my lord, case was, here they are not hardened criminal, only because not giving sight to the car, my lord, heat of the moment there is a, so already I am losing in appeal also. But there's a evidence scope is very limited. But in most of the cases, my lord, I have seen, my lord, even the court, my lord, it's converted to either fine or to the provision of offender act. Even a very recent judgment of our High Court also. I want to place some PESCO judgment also. Then, my lord, if your
When?
lords, my lord,
Tuesday?
my lord, Tuesday, Tuesday, my lord.
Tuesday?
So I'll,
Otherwise, you see, Mr. Mohanta, this is the revisional.
no, that I understand, my lord.
Correct. Now, what was argued by your junior is that the evidence have not been fully taken into account.
My
But
lord.
that cannot be an argument made before the revisional court, because the revisional court cannot appreciate or reappreciate the evidences, right?
Correct.
What is to be pointed out is that if there is an error apparent on the face of it, it has to be a point of
My
law,
lord,
correct?
my lord.
Now, nothing has been pointed out. In fact, we have gone through the evidences, both the judgments.
My lord.
It appears that on the basis of evidence, both the trial court and appellate court has taken a view.
No,
Now, even if we think that view is not right, and or we may think there's another view, even that cannot be a ground for interference.
my lord.
Right. Now, there is evidence that there has been an assault. Medical evidence also.
My lord. No, that these are, my lord, 320, my lord, only 3 months, there's a petty
Very
offense, my
well,
lord.
you are now you are trying to say if it can be converted into
The
fine.
fine or, my
or-
lord, but there's
So
a,
that show me if something
my
is
lord,
there.
I'll place on the judgment.
All right,
Thank you,
we list
All right.
on Tuesday for further hearing.
my lord. 22, no? Oh, I think
Matter
there's
remains
one
as
again.
part heard.
My lord.
Item 19. My pleasure. My lord, this case relates to the quashing of the proceeding, my lord, but my learned brother,
TCR and Senate.
My lord, I am representing my lord.
the informant, my lord,
October 2, but my
Huh?
lord, he expired, my lord, on 3rd of October.
Who expired?
informant.
Informant complainant.
Oh,
So,
informant has expired.
my lord,
Yes.
it did you need?
What is to be done?
My lord, case has to be,
Pass any order, we have no.
No, what order can be passed? Now, this is the petitioner is the accused.
It was.
I was the accused, but the informant, my lord, he died.
Informant died doesn't mean that what is the order against which you have come in?
My lord, I have challenged the impugned FIR that your lordship.
There has been a stay.
Yes, yes,
That case has not proceeded.
not possible. Okay. Proceeding has been stayed, man.
Huh?
Proceeding has been stayed,
No,
man.
that's what proceedings have been stayed.
Yes, yes. Lordship will see page 20 is the FIR, my lord. It is basically money suit, my lord. Lordship will see page 20.
Let the police complete.
Yes, yes.
Investigation. Charge sheet
Investigation.
has-
Charge sheet submitted, my lord.
Mr. Locker,
Charge sheet
matter
submitted.
can be sent back to the magistrate's court.
No, my lord. Charge sheet I have annexed already, my lord.
See, the problem is charge sheet, if makes out a prima facie case, how can this court quash that charge sheet? Merely because the informant has died?
No, my lord, not that, my lord. Lordship kindly have a look, page 20, my lord. I came to know today only, my lord. Lordship will see the page 20. It is,
Yes,
may I read, my lord?
yes.
I am the permanent resident, the above noted address in this connection, as I beg to state that the above name accused person had taken an amount of rupees as a loan from the account through check. When I asked the refund the money, I needed the money. The accused, instead of refunding money, came to my sawmill in my absence and scolded me with a slang language in front of my employee, and I asked to close mill by various threatening. In this regard, I defame in front of the employee and amounts threat to the life and business. The accused again demanded the money from
Civil.
civil, my lord. And I have refunded that money also through RTGS.
Where?
That your lordship will see. I have given him initially check, he did not. Then RTGS I have sent, my lord, page 34.
Mr. Locker, I think we can close it. Page 34.
Lordship, this is the RTGS slip, my lord. 2 lakhs is the principal amount and 40.
Right, heard Mr. J.I. Borbhuya, learned counsel for the petitioner. Also heard Mr. C.S. Chauhan, learned counsel appearing for the respondent, two-stroke informant, and Mr. P.H. Locker, learned APP for the state respondent. By way of this petition under
480.
Section 482 of CRPC 1973, read with Section 397401 CRPC, read with Article 227 of the Constitution of India, comma, the petitioner is seeking setting aside and quashing of the impugned FIR of Polasbury PS case number 86/2019, registered under Section 417, 420, 447, 294 capital A /506 of IPC. And the impugned charge sheet dated, charge sheet is dated
Dated, my lord, 26/6/19.
26/6,
19
1990.
at page 35.
Impugned charge sheet number 147/19 dated 26/6/19. And the further proceeding of PRC case number 245 of 2019 under section 406 IPC. Correct?
My lord.
So for the the magistrate court has framed charge under 406 after the charge sheet. Charge sheet is under section
406.
406. Okay.
Page 35, last 3 lines.
And the proceeding of so and so case the DISA originate from the aforesaid FIR pending before the Court of Judicial Magistrate, First Class, Kamrup, Amingaon. Done. The brief facts of the case is that the respondent number 2 filed an FIR dated 7/3/19, 7/3/2019, alleging inter alia that the petitioner had taken an amount of rupees 2 lakhs as loan from him, and when he asked him to refund the money, he, instead of refunding the money, came to his sawmill and scolded him with slang language in front of his employees. It is further alleged that accordingly he was defamed in front of public and employer. Stop. It appears that the said FIR, well, no, it appears that the said accordingly the FIR was registered as Palasbari Palasbari PS case number 86 of 2019 under section 417, 420, 447, 294 capital A 506 IPC. Thereafter, the investigation, upon the investigation being completed, the investigating officer submitted charge sheet by charge sheet number 147/19 dated 26/6/2019 under section 406 IPC against the petitioner. On the accordingly, matter was before the Court of Judicial Magistrate for accordingly PRC case number 245 of 2019 was registered and pending was registered before the Court of Judicial Magistrate, First Class, Kamrup, Amingaon for trial. Correct? Isn't it? For trial. Stop. At the situated thus, the petitioner has filed the instant revision petition, criminal petition for quashing the said FIR and subsequent charge sheet. Stop. Mr. So-and-so, learned counsel for the petitioner submits that there is no,
Right, my lord, legally are not interested to pursue.
Who has given you that instruction?
That is the daughter.
Where the daughter is a party here?
No.
Please take your seat, Mr. Counsel. Mr. Counsel, please take your seat. He submits, Mr. Counsel, please do not interfere when the court is dictating an order. please, if you have anything to say, you can always say it after the dictation is over because it disturbs the flow of the dictation. मैंने तेरा नाम तो लिखी पहले क्वेश्चन ना submits that there is no submits that a bare perusal of the FIR does not indicate the ingredients of section 406 being present in the body of the FIR. Stop. He accordingly submits that no criminal case whatsoever is made out from the FIR. He accordingly submits that further continuance of further criminal proceeding is wholly unjustified. Stop. Per contra, Mr. S. Chauhan, learned counsel for the respondent number 2 submits that in the meantime, the respondent number 2 has died. Mr. He further submits that in the meantime, this payment was done prior to the charge sheet or after the charge sheet?
My lord,
After.
firstly, I given the check, he refused, page 29.
He submits that submits that the loan amount in question has already been returned by the
RTJ.
petitioner to the respondent number 2 on 10/9/2016 and 10/9/16. Stop.
10/9/19, my lord. 10/9/19.
10/9/19. Mr. Chauhan, learned counsel for the respondent number 2 submits that pending adjudication of the instant of the criminal petition, the respondent number 2 expired on 3/10/2024. He further submits that the daughter of the respondent number 2 has expressed her intention not to pursue the criminal case further. Stop. Mr. Locker, learned APP, fairly submits that at best it's a mere breach of trust. A case of mere breach of trust can be said to made out on the body on the averment set out in the FIR. Stop. Heard, perused. Apt to reproduce the FIR dated 7/3/19. Have to refer to the FIR dated 7/3/19, which is reproduced here under for ready reference, quote unquote, page 20. A to A. Apt also to refer to the, it appears that on the basis of the efforts at FIR and upon completion of the investigation, charge sheet was submitted against the petitioner under section 406 IPC. In order to attract section 406 IPC, allegation of fraudulent misappropriation and is essential. In the instant case, it appears that the dispute relates to mere breach of trust. Mere breach of trust does not constitute criminality, and as such, no case of criminality upon the play up on the averments made in the body of the FIR can be said to be made out. Hence, the impugned charge sheet is bad stuff. That apart, it is evident that the petitioner has already repaid the loan amount to the account of the respondent number 2. It further appears that during the pendency of the instant petition, the respondent number 2 has expired, and Mr. So-and-so, learned counsel appearing for the respondent number 2, has submitted before this court that the daughter of the respondent number 2 expresses her desire not to pursue the criminal case. That being so, in the interest of justice, the impugned FIR charge sheet for the proceeding in so-and-so case stands set aside and quashed. Criminal petition stands allowed.
Item 20. Item 20.
None appears for the petitioner on call. List after 2 weeks on a date to be fixed by the registry.
Item
One
22.
second, one second. None appears for the petitioner on call, and anybody there for respondent? You are there?
No, I had for the state.
Mr. So-and-so, learned APP is present for state. In view of relist Friday dated by on such and such date in the order column with the remark for dismissal.
Item 22.
Yes, Mr. Day.
Is for quashing a complaint, my lord.
Complaint registered under 294506.
Yes, my lord. Only thing, my lord, one of the petitioners, she will be probably 90 plus. 90.
Huh?
One of the petitioners, she will be
You
probably
want
90.
to find
90.
out the status?
I'm not exactly sure whether if she's alive or not, my lord.
Hey. Get in touch with your client.
She'll be probably 94 now. The petition number 3.
I can have it on the next week. You try and get in touch with your client.
Yes, my lord. My lord, petition number one is young. She is alive, I know, but there is no connection as such. But the petition number 2 is 67, and the petition
Which
number
is the
3.
case, which is the order that you are?
My lord, here cognizance was taken. That I'll just. 35. Page 35, my lord. So basically, what had happened, my lord,
Where is the complaint?
complaint your lordship will find it. Page 22. In fact, prior to that, my lord, I had filed a complaint. It is basically, my lord, they are
You are
living.
Gunjita Ahuja.
I'm Gunjita Awad. That your lordship will find page 18. That was the initial complaint. At one point of time, this was filed, but thereafter she got married. The petition number 1, she got married. She shifted to Guwahati. She was residing here. My lord, basically it was
Got married.
the petition number 1, my lord.
Who is petition number 1?
She is Gunjita Ahuja.
You are representing the complaint.
Yes, yes, my lord. No, my lord. That was the first case, my lord. This was the complaint which was filed by me earlier. And page 18, annexure A.
The page 18 says name of complainant is Srimati
Yes, my
Gunjita
lord.
Ahuja.
That is the, here, my lord, I am the accused number.
So that's why I am getting
I'm
confused.
understanding, my lord. In the other, in page 22, I am the accused number 1.
In page 18, you are accused
18,
number-
I am the complainant. I was the complainant. Initially, I had filed a. Initially, I
All
had.
right, I stand, I now understand. Page 22 is you are accused of.
Yeah, yes, my lord. This is the
Yes,
complaint
what-
which
let
I.
us first see 22.
Lordship. Here, my lord. In fact, my lord, in this complaint, my lord, reference has been made.
Polita, you are for the husband.
Husband, madam.
Uncle.
Cousin, madam.
No, uncle over. Uncle over. Gunjita uncle over. Mama over. So, Kura over.
All right.
Now, what had happened, my lord, page 23, as reference to paragraph 6,
You
my
are
lord.
Vikas Kumar Ahuja. Yes.
Now, Lordship, I take you to page 23,
Yes.
paragraph 6.
Yes.
That the accused number 1 filed a case against the complainant and listed witness white case number CR 602 of 12 under section 294, 448, 323, 54, 376, 506, IPC read with section 66E and 84C of the Information Technology Act, wherein accused number 2 and 3 were listed as witnesses on 4/9/22 12 before the court of learned SDGM Hojair Shankardev Nagar, alleging inter alia that the complainant is a bona fide citizen of India and a permanent resident of house number 27, ward number 6, Thakurbari Road, PS Lamding, and residing there here in a self-owned house of her grandfather, late Chunnilal Ahuja, along with her widow, mother, and grandfather. The accused Vikas Kumar Ahuja and Srimati Rekha Ahuja are uncle and auntie. The accused persons are residing in the same residence, forcibly occupying more than half portion of the property of the complainant. That the accused Vikas Kumar Ahuja, father late Lachmanan Das Ahuja, was the brother of said Chunnilal Ahuja, grandfather of complainant. During lifetime of the complainant's grandfather, said brother Lachman Das Ahuja and his wife, 1 or 2 granddaughters, and to stay in the aforesaid house because said Lachman Ahuja was unable to do so any independent business and also unable to maintain his family. The grandfather of the complainant in his way sheltered to the accused Vikas Kumar Ahuja, helped in his education and in his upbringings. That since the death of the complainant's granddaughter, the accused persons continuously trying to grab the vast movable and immovable property of her grandfather by instituting false cases, by intimidating the complainant and her widow, mother, and grandmother with an intention to kill them. The complainant and her widow, mother, and grandfather are now under constant threat from the accused persons. The accused from the childhood of the complainant used to exploit her sexually, which the complainant realized at a stage. During her adolescence period, the accused molested her several times and threatened her with dire consequences not to disclose to the elders about his misdeed. The complainant silently accepted all verbal, physical, sexual torture day by day as she is a posthumous lady, and only grandfather was her shelter. That the accused, understanding the disadvantageous situation of the complainant after the death of her grandfather, escalated his domestic violence on her by putting mental torture with an intention to eliminate her from by though constant physical and mental harassment, which may provoke the complainant to commit suicide. That the accused residing unauthorizedly in the house of the complainant's grandfather, using the common courtyard and passage bathroom, created obscene gestures and postures and often harassed her in broad daylight. Once the complainant collected courage and opposed vehemently along with her mother and grandmother against such misdeed, with accused mother Sri Gunjita Ahuja and Rekha Ahuja, they have common interest to grab the property before infatuated and assaulted the complainant and her mother, slapping, pulling hairs with fist and blows, and threatened them to move violent actions in future. Do not vacate the property. The complainant family, this is basically the complaint at page 18, my lord. The lordship may even skip this part. Now, lordship, I'll just take you to page 26. This is basically the contents of the complaint which your lordship had seen in paragraph page 18. Second paragraph. Finally, on 5/9/2016, Learned JMFC says J. Das passed an order that the complainant is absent without steps. Accused person Vikas Ahuja is present. No witnesses present. Peruse the case record in its entirety. It appears that the case is pending for a long time at the stage of evidence. The complainant hasn't adduced evidence nor appeared in this case for several last dates. Today also the complainant is absent without steps and no evidence has been filed. Even there is a direction by this court to lead evidence today without fail by the complainant side. Hence, in view of the above, it is a fit case to close the evidence of the complainant. The instant case being a summon procedure 1 is in view of section 256 of CRPC. The accused person is acquitted and bail bond furnished on this
So
behalf.
that case has been, you have been acquitted in that case.
No, my lord. I was the complainant in the other case. So
Sorry,
here, my lord, because
the husband was, that boy was acquitted.
yes, my lord, her uncle, my lord. Now, what had happened, my lord, because of her marriage, she shifted to Guwahati. And at that point of time, the grandmother, the petition number 1, the petition number 1 is 2 is the mother of the petition number 1. Petition number 3 is the grandmother of the petition number 1, who was aged 88 at that point of time. So, my lord, ultimately she came here, my lord, the case was case remained uncontested. In fact, the case, this orders under 256 was passed. Now, Lordship will take it to page 27. There is a landed property dispute between the complainant and the accused person. The accused person, to grab the whole property and to pressurize the complainant, filed a case against the complainant with some false serious allegations like rape, outraging the modesty of a woman in CR case number 602 of 12. That is page 18. That the accused person, number 1, Gunjita, who is in her complaint number so and so, in para 5, also in initial deposition, specifically and clearly mentioned that the accused Bikash Ahuja, from the childhood of the complainant, used to employed her, she ought to have been exploited, her sexually, which the complainant realized at a later stage. During her adolescence period, the accused molested her several times and threatened her with dire consequences not to disclose to the elders about his misdeed. The complainant silently accepted all the verbal, physical, so and so, but day by day, as she is a postmortem lady and only grandfather was her shelter. And the accused number 2 and 3 deposed that the preliminary of deposition and supported the and corroborated the statement of the accused number 1. That the said allegation of rape of by the accused number 1 against the complainant, who is the uncle of the accused number 1, spreads like fire in the Lumding market and also outside of Lumding. The said accused persons also spread the message of rape and to their friends, relatives, neighbors, clubs, Mohila Somiti. As a result, the allegations and imputation made in the CR case number so and so against the complainant per se defamatory. So it was basically in the lines of a defamation case, my lord. Causing and resulting in serious harm, damage, and loss to the reputation of the complainant in the estimation of others, and also harm and damage to the good reputation of the complainant as a principle of Saraswati Gurukul and the social worker. That the said false, baseless, and concocted
What is registered against you?
here, my lord, 294. I'll just take it out. 294, 506, and 34.
Item number 1 or displayed. 294 is defamation.
No, my lord, it's a obscene language or
And 506?
criminal intimidation. Initially, the case, what he tried to make out his
But,
case.
See, you have a point. It appears that you had earlier filed a case. But then that case you never contested.
But that is true, my lord. That is what, my lord.
Now he has filed against you where there are a lot of allegations.
No, allegations are there, my lord. That is
Now,
what
when there are allegations, how will this court set it as quash it at the outset?
I'll just place what.
If suppose there are no materials.
No, my lord, here,
you are-
basically, if your lordship, that is what I was trying to point out. In the complaint, the basic contention was, he was defamed. It is not a case of, it ought to have been a case of 499 or 500, my lord.
He was defamed, that's right, but then there are allegations that you
No,
have
no,
molested,
no,
you
no.
have taken
I was molested, my lord.
advantage.
No, my lord, that is
Sorry,
wrong, my lord. I was molested.
Sorry, you.
Well, I was
he
molested. It is the case of the petitioner that initially I filed a complaint alleging that my uncle molested me, my lord. That got dismissed. This is the contention, my lord, in the complaint which was reproduced in the complaint filed by the respondent number 2. Sorry, respondent, not respondent number 2, my lord. So after, my lord, my case was dismissed for default, the respondent filed a complaint that the case was dismissed.
What are the allegations about obscene acts and songs?
My lord, what had happened, my lord? The election, no, that is what, my lord. There is nothing as such. I'll just point it that.
Huh?
Paragraph 16, page 30.
Page 30. Paragraph?
Paragraph 15, madam.
What is obscene and what is obscene
my lord,
here?
what is,
And my lord, paragraph 14, last part of page 29. And moreover, my lord, SARS can be ordered at any time. That is also there.
But what charge? What section will be?
Cognizance, my lord, initially.
Which will be the appropriate section? Because defamation, nothing is made out. He has filed a complaint case that was not published in any notice.
Exactly.
How will it be defamed? He's already in that case, he's already acquitted.
He faced that case for 4 years.
For that, you can take some other action he can take. That is different. But not filing an FIR, what is the criminality?
FIR, madam, it is
There could be hundreds of reasons for the girl not to pursue
pursue.
that case. We don't know. The case was not a clean acquittal also because the complaint didn't
prosecution.
correct.
So.
Here-
Yes, you want to draw something from.
Yes, my lord.
14?
What Lordship will kindly appreciate one thing, my lord.
1 second, Mr. Dev.
Sorry, I'm sorry.
14, what you wanted to show?
The
No, I am only asking you both to show me where are the allegations of 294 and 50.
6.
Only that part. According to Day, it is not there. Mr. Kolita says it is there. Please show. Where is it?
I'm reading, madam, the
Yes.
last part, madam. The
Where?
That's it. 10th line, madam, from the below, madam,
Page 8, page 29.
is 29. So they are asked to take shelter by so and so. But initially, there are several cases pending between the parties, madam. Some cases were started, some cases were final report filed, madam. So civil court further, I beg to report that on 14/8/2012, Srimati Gunjita Ahuja has lodged an Ezahar at this PS against Srimati Renuka Ahuja, wife of Sri Vikas Kumar Ahuja, representing the complainant in this case, Ahuja, for criminally trespass into her house and assault her.
Yes,
It-
what is, where is, the ingredients of 294 and 506 in this last part?
Fine, 294, this part,
You
my lord,
show the allegation is there. I will not look into the correctness. If allegation is there, I am not interested.
94, my lord, that paragraph 15 itself, man.
15 is not obscene.
Uh,
15.
What word used, that is not, my lord,
Mr. Counsel, you are the complainant. You know what was the word used.
my lord, here simply.
It was up to you.
Yes, my lord. That's
And
other-
going by the long history of between you both, it is very clear that it appears this complaint has been filed with a bona fide intention.
Well, initially complaint was, while complaint was filed, 500, all the sections, lordship will find at page 22, all sections 294, 500, 120B, railway section 504, 506, all were quoted. But
You have not challenged the charge, sheet, the order whereby the charge was framed. You have accepted.
04, my lord. What is, my lord, that if the, my lord, learned code below, if, my lord, presume that there is a material to proceed, my lord, then, my lord, cognizance may be taken. That at the time of, any stage, my lord, on the basis of the evidence recorded during the
I
trial.
can do one thing. I can remand the matter back to the magistrate court. And of course, I will say that prima facie no
My lord,
material as per 294 appears.
your lordship,
And
please.
let the magistrate court, after reappreciating the materials
thing-
collected by IO, apply its mind.
Only there is another aspect of the matter, my lord. What else I was trying that my
Sorry,
lord.
Mr. Kolita, take your seat.
I'll
I'll
just,
come back to you.
Yes.
now Lordship will kindly appreciate one thing, at page 26.
Page?
Page 26, the complaint filed by me was dismissed on 5/9/2016. Now Lordship, what has happened is, at paragraph 15, my lord, which my learned friend has referred to at page 30.
28.
26, my lord, 26 is the date, my lord, when the case, my case was dismissed for default. That
Hmm.
is 5/9/2016.
Hmm.
Now-
And on 28/12/18.
Now, Lordship will see page 30 again, that on 28/12/2018, it is the case of the complainant that we three, my grandmother is bedridden. She is unable to move.
But those
That,
are-
no,
see,
but that,
Mr. Day,
because my lord, in other cases, my lord, the court is well informed, my lord. In fact, she has been made accused of the,
that you can't. It'll be
no, my lord, because
difficult.
my lord, now, Lordship, only thing, I'll just take you to
Let's have it on another day with a fresh mind. I'm not inclined.
I understand, my lord. Only thing, my lord, even in the depositions which are already on record, my lord, nothing comes up, my lord. Because, my lord, the complaint, no doubt, my lord, it has to be supported by the evidence, sorry, initial deposition of the,
Trial is yet to begin.
true, my lord. But for the purpose of taking cognizance, something has to be there. Now, if
When?
you, in the
When?
any date, my lord. Other than 26, my lord, 26 are number of cases are fixed, my lord.
After the whoever did you?
Yes.
We list.
No, there is an interim order, my lord. that is fine.
Interim order to continue till then. You look into again.
Here was a case, my lord, where I was in the advanced stage of pregnancy, my lord. There are documents to show that I was in Guwahati at that, on that particular
See,
day.
Mr. Day, you
The plea of
know,
LEV, I understand,
you
my lord,
know
but
the narrow encompass
I understand,
within which
I understand,
you
that is there.
are. These are things which can be looked into only at the trial.
Really?
I'm not conducting the
No,
trial.
that is true, my lord, but even
You
there is,
have
my lord.
to- Because some of the allegations are there, threatening.
No, my lord.
These are allegations.
Threatening, I was threatened, my lord. It is probably
No, in para 15.
15 years, my lord. That is the date, my lord. Now, lordship, 2 years went
So
by.
now whether that allegation is correct, not correct, how can this court go into it?
Only thing, my lord.
You rethink. I am only
No,
expressing.
I understand.
My mind.
My lord, only thing that
Difficult.
has to be, my lord, paragraph 15 has to be supported by the
Because
initial-
you want to bring this case under that exception, under I think condition number 7 in Bhajanlal. Perhaps you want to bring it.
in fact, my lord, it is out of grudge, my lord. Yes.
Correct. You want to bring
Nullified,
it
yes, my lord.
there. But simply of the fact that few years, because that FIR was filed long back, isn't it? Which ultimately already acquitted. That doesn't mean that subsequently something may not happen.
No, it
I
is-
could have understood if immediately within a week, within a month also, if something was, it could have been termed as an afterthought, you see. But this after so many years, this FIR has been filed.
The complaint, my lord, is a
Complaint has
complaint.
been filed after so many years. So how can this court simply quash it at this stage by assuming that it could be out of grudge? There has to be something more, Mr. Day.
That is true, my lord. I will place, my lord,
There has
because,
to
my
be
lord,
something.
15 has to be,
Because if these allegations were not there, nothing like it. But
except for, my lord, except for paragraph 15, there is nothing on record.
15 talks about threatening.
I understand, my lord. But,
Then
my lord,
What
that
about
has
506?
criminal intimidation. What is 3 ladies, my lord?
You
Firstly,
think over.
yes, my lord, that I'll do. my lord.
That is the only reason I'm giving you time.